Thank you. Please be seated. Good afternoon and welcome to Division 4 of the Colorado Court of Appeals. My name is Bob Hawthorne. I will be presiding judge for these proceedings. To my right is Judge Fox, and to my left is Judge Harris. We will constitute the division that will be deciding and writing an opinion on the two cases that we have on the 130 docket and one case that we have on the 230 docket today. Before we get started, let me say just a few things. First of all, remember we are live streaming our oral arguments today. So if there's anything in the cases that we'll be hearing that's sensitive or confidential, please keep that in mind. As far as those folks waiting in the audience or the gallery here, if you have a cell phone or any other kind of device, please make sure it's turned off so it won't interrupt the court or the parties in their arguments. With that, have the council had the opportunity to read our practice and protocol before the Court of Appeals, and do you have any questions on any of those?
No.
Okay. And as far as appellant, the both sides, the timing is self-monitoring. You have that on the podium. And as far as the appellant, you can reserve the time that you want to for rebuttal, and that's self-monitoring also. So with that, our first case is People versus Claybaugh, or Claybaugh. That's 2017 CA 175, and we're ready to proceed on that case.
May it please the court. Tanya Karimi from the 4th Judicial District Attorney's Office on behalf of the people for the appellant, bar number 41693. In evaluating a motion to continue, a trial court should consider the unique circumstances of each case and balance the equities on both sides. There is no mechanical test when evaluating a motion to continue. The circumstances that can be considered are the materiality or whether an unavailable witness or an unavailable piece of evidence is material to the case. Also consider the due diligence of a moving party in making that evidence or that witness available, the effectiveness in securing and making that evidence available, the prejudice to a moving party, and whether the continuance requested would cure that prejudice, and also the prejudice to a non-moving party. Here, the trial court did abuse its discretion in denying the motion to continue and dismissing the people's case, because although it found that the people exercised due diligence in making a witness available, they found that the witness, the victim, was reluctant and would be testifying for the defense. This finding that the victim would be testifying for the defense is not supported by the record, but just as importantly, the crux of a decision on a motion to continue should not hinge on the supposition of how a witness will testify. It should instead reflect the availability of that evidence, the availability of that witness. Here, the prosecution sought a continuance, not just because the victim wasn't present. Indeed, the main reason for the continuance, it was made even before trial, at pretrial readiness, was to determine the evidence that the victim would provide. The victim, within 2 weeks of trial, had contacted the DA, or the DA had contacted the victim, and told the prosecutor that her testimony was changing, that she would be testifying for the...
And given that information, why wasn't it reasonable for the trial court to infer that it was changing, not in the prosecution's favor?
With victims, that may not always be a reasonable inference. The fact that the people went forward with the case suggested the evidence that they had, or the statements they have, supported the charges. If the victim tells them that their statement has changed, it could mean the evidence isn't supported, or it could mean something else. A witness doesn't always understand the legal requirements. I think for a court to make that inference is an inference too far, just based on the fact that victims saying their statement has changed. That's not taking into account prosecutor's evaluation of whether impeachment on that would be likely, or maybe the person is changing their testimony on something that's not relevant to the elements of the offenses charged. I think it's just an inference too far. I don't think it would be reasonable within the context that there's not enough information about what has to be proven.
Well, counsel, I believe you said that this information came to the prosecution's knowledge about 2 weeks before trial. Is that
It
correct?
looks that way from the record.
And the motion to continue was asking the court to continue so that the prosecution could find out what the witness, have an investigator go out and talk to the witness. Is that correct?
That's correct.
But they never did. Why did they not do that
And
while the motion was pending and find out what the witness would have said?
And the record doesn't show what efforts were made in terms of investigation. What it does show is there were 3 days between the request for the continuance and the morning of trial.
So that meant there was about another week, over a week, from the time they gained the knowledge until they filed the motion. And there's no evidence that they made any attempts to try to find out what the witness was going to say. They didn't send out an investigator immediately to find, after gaining that knowledge from the witness, to find out what was going on. Is that right?
And the record, correct, the record doesn't show particularly what individual steps when the investigator went out and how, or if one was sent in the meantime. But the prosecutor represented that he needed that time. And I understand the court considering that, and that should be considered, but in addition to that, as I said, it's not a mechanical test for determining whether a continuance is warranted. There's a weighing of the circumstances, and that includes the equities to both parties. One of the factors that was not explicitly weighed by the trial court here was the prejudice factor. And what ended up happening for the people, the prejudice was huge. The case was dismissed, and a continuance within speedy trial, the prejudice was much, much less to the non-moving party, to the defendant. This is a case where the defendant had bonded out. He was not in custody. It's a case where the continuance was requested 3 months after the trial setting, so 3 months before speedy trial would have run. So it's in contrast to other cases, even cases under the speedy trial statute, where the prosecution is seeking to continue beyond speedy trial. Here, in particular, that equity weighs in favor of granting a continuance because the prejudice to the people in dismissing the case is severe, and the prejudice to the defendant, while he has to wait for trial, he is not being held in custody, and it's not going beyond speedy trial.
So can I just zero in on that for a second?
Yes.
Because it seems like, under the case law, what we're supposed to look at is the prejudice in conjunction with whether or not the continuance is going to resolve the problem that's prompting the request for a continuance, right? So, and it has to be, we have to look at it from the point of view of the judge at the time the request for a continuance is made. So here, at the time the request for the continuance is made, the prosecutor says, I need more time to send out an investigator and determine what the victim is going to say. The prosecutor does not ever say, regardless of what the victim is going to say, we will need to have the victim here, Judge. So just so you're on notice, like in Sinet, if the victim does not appear, of course we will be asking for a bench warrant, because regardless of her testimony, we will need her here. Instead, the prosecutor says, we need to go out there and find out what she's going to say. So the prejudice in not granting the continuance is that they won't be able to go out and find out what she's going to say. That's what the prosecutor says to the judge. So the judge says, well, if that's the problem that's prompting your request for a continuance, the continuance is not going to solve it because you have just told me what she's going to say. The prosecutor, in fact, represented to the judge their best information about what the victim would say if they sent an investigator out there. So why is there's a mismatch now? Now you're saying, well, really they just needed to have the witness come. But that's not what they told the judge. And we're kind of bound by what the prosecutor told the judge.
Well, the prosecutor told the judge, yes, that he needed the continuance because the victim said her statement was changing.
Right, to find out what the victim would say if she came in to testify.
And they were also able to determine at that pretrial hearing, the victim had also said that she would be testifying for the defense. And the defense represented that, no, they did not have her under subpoena. She was not testifying for the defense. So from that, it's not clear from the record what exactly that victim's testimony was going to be.
Okay, but the problem that was identified, that was prompting the request for a continuance, was to discern what her testimony was going to be, right?
Yes.
Okay, and the judge says, well, if that's why you need the continuance, then I can tell you what her testimony is going to be because you just told me what you think it's going to be. You had a phone call with her and she told you, I'm changing my story, I'm going to testify inconsistent with the statements I made on that night, and I'm going to testify for the defense, which the judge inferred to mean I'm going to align myself with the defense now. So the judge says, if that's what you need the continuance for, then we don't need a continuance.
And
what's wrong with that? Because the judge has to decide whether the continuance will resolve the precise problem that's prompting the request.
the problem, I argue, with that is that the record doesn't support that conclusion, that hard conclusion that, oh, this victim's going to testify, has changed her story, is going to testify against the defendant. There could be other reasons. It could be the change in the victim's testimony is not something that affects the charges. And it's what I addressed with Judge Fox.
I think that's a little speculative.
And
To say it's not going to be relevant to the charges. I mean, why else would you need her then?
But part of the diligence that the prosecutor is exercising is not only the availability of the witness, but the type of evidence that there's going to be. Just based on the statement from the witness that her statement is changing, that's insufficient. I argue that's insufficient.
What about, is there any other reason why you think that's problematic? So you say one reason is because it's based on an incorrect inference or an unreasonable inference based on what the parties had just told the judge. Any other reason?
The most problematic reason is having a court make a determination about what a victim is likely to testify and let that be the crux of why a case can't go forward. That a victim who doesn't want a case prosecuted, that opinion or that likely testimony, that's going to control whether a continuance is granted or not. Testimony can change, witnesses can change their mind. Giving that type of control to a witness coming in, especially a victim in domestic violence cases, the court should focus on the availability and the diligence of the people. I'd argue not just in making the witness available, but in determining what that testimony is going to be. Here, the prosecutor said the purpose was to determine whether her statement had changed because she was critical to the case, and also because a change in her testimony could have affected the level of the felony or the misdemeanor that could have affected the charges. And that in evaluating prejudice, that a finding or getting a determination on that type of evidence, that would also be beneficial to the efficient administration of justice, but also the defendant knowing what type of testimony is going to be presented.
But the prosecutor also had another available remedy, which was to actually ask the court to compel the witness to attend. And that was not requested, so why should we second guess the trial court's call, given that that was not, the prosecutor didn't avail him or herself of that? And
Looking at the reason for the continuance, the main reason being to communicate with the victim, the prosecutor, it's reasonable to expect that maybe the prosecutor wants to have that option to not have to request that bench warrant, not have to interview that victim while that victim's in custody, to request a continuance and receive that continuance without having to further alienate a victim by having the investigator meet them in the jail. The other thing the record shows is that the prosecutor didn't have a chance to even make that request. The prosecutor requested for the continuance for the purpose of talking to the victim again, and then the judge turned to the defense objected for the reason that the victim didn't want the case prosecuted, and then the court dismissed the case. And when the court dismissed the case, the focus wasn't on the availability of the witness, the focus was on the witness would be testifying for the defendant.
I don't buy that the counsel did not have an opportunity to ask for a bench warrant. I mean, the prosecution could be asking for a continuance, and if you're not going to grant the continuance, Judge, I'd like to have a bench warrant to bring that witness in here so we can put her on the stand and find out what she's going to say. Testimony, you said it yourself, testimony changes all the time, right? So we don't really know what the witness would have testified to, despite what she would have told an investigator, until she was on the stand. So
Plus, bringing her into court could allow for impeachment, which could have made the prosecution's case for them, right?
There are all possibilities, but in weighing all of the circumstances together, that the choice to prosecute this case was not to make assumptions about the victim's testimony, but to have that chance to speak to the victim, to get that evidence before the court, get that evidence and discovery so that both sides would be prepared. And considering the defendant was out of custody, and this was well before the speedy trial deadline, when all those factors are weighed, to focus on the one factor of what the victim was likely to testify about was an abuse of discretion.
thank you, counsel.
May it please the court. Nathaniel Deacons, registration number 38752, on behalf of Mr. Claybaugh. I think, Judge Harris, what you're asking about in terms of the prejudice to the prosecution is perhaps the most important factor that the judge weighed. And while the language the judge chose in terms to express the factors that she considered in denying the motion to continue weren't in the exact words of the cases, I think the judge, when you put it in context and you look at the factors the judge considered, the judge hit almost every point that is relevant to the determination, or at least that the appellate opinions addressing this topic have said are the most important. And in this case, I think the ability or the ability of the continuance to remedy the prejudice, I think that is the most important factor here. And the judge considered that and said it's highly unlikely. I think in a different case, counsel's point about the fact that the victim might testify for the defendant it would be different under different circumstances, but it's not. That's not what the judge meant here, I don't believe. It's just that court was addressing what is the likelihood that a continuance will remedy what you are looking for here. You had the week and a half, as Judge Hawthorne said. You didn't do it. You had the 3 days over the weekend. You didn't do it. And it's unlikely based on what the prosecution's own record that the victim was going to even cooperate with the DA or an investigator. So I think that is the most important factor here, and the judge considered other factors as well. And the judge considered the totality of the circumstances, believed that it was proper to deny the motion to continue, and as a result, only as a result of that was the case dismissed. I think the prosecutor below, I can't remember his name, but it's not important. His words and actions are telling too, in that he objected for the record, and he didn't have much to offer in terms of why he hadn't acted. I'm not quibbling with the due diligence finding necessarily, because they did have the witness under subpoena. However, they didn't do all these other things that they could have done and what they said they wanted to do in the time that they were given.
Counsel, what's your position on what the legal effect of the prosecutor's failure to request that a bench warrant issue, what that legal effect would be under these circumstances?
I think that at the very least, for Mr. Claybaugh, it's a strong factor in the totality of the circumstances analysis and how this court should address what the district court did. I also think that under the circumstances of this case, it's an independent basis to affirm the judgment, because just having the witness under subpoena on its own is not enough to satisfy the due diligence standard. Now, I haven't found a case that says that. I think this might be the case. My opposing counsel cited cases that stand for the proposition that not having the witness under subpoena doesn't necessarily mean lack of due diligence. And I think the opposite is true, that having a witness under subpoena on its own doesn't equate to due diligence in every case. I think this is the case because of what the prosecution, when they found out about the victim's change in her testimony might be, or change of heart, or what have you, didn't pursue that. It sounds like the defense also found out quite a bit before this. Now, I don't know how much to read into that, because communication can be different between the different sides. Nevertheless, about a week and a half before the pretrial conference, the prosecution found out about this and didn't follow up with an investigator, which would be prudent to do, especially given the trial date that was coming up. And of course, the judge has a busy trial docket, as well as other matters.
Can I ask a quick question about the factors here? The way I read the factors that the judge should consider are the prejudice to the moving party, and in conjunction with that, whether the continuance would remedy the problem that's prompting the request for the continuance, and the prejudice to the non-moving party, so here, Mr. Claybaugh. Is there any reason to think that then, once you do that, then there's also some extra factor where, although you've just done that, now you're supposed to weigh other prejudice that might have, that might be incurred by the moving party, in addition to the prejudice that they have talked about on the record to the judge? That wasn't stated.
I'm not sure I
Okay.
100% understand, but I think I know what you're saying.
So there's prejudice that is supposed to be remedied by the continuance. Are
Yes.
we supposed to look at all other prejudice that we think might be out there somehow and might affect the prosecution or the defendant, depending on who's asking for the continuance? Or do we focus only on the prejudice that is stated on the record as the reason for the continuance?
Okay, I think I understand your question.
Okay, great.
Well, I think that the onus is on the parties to state their positions. I think that the answer to your question is no. The judge must rule on the motion to continue with the information that is provided to it, and in the context of the case, of course. But the onus is on the district attorney in this case to make their record as to why they need the continuance, and the judge's ruling was responsive to that in this case. And for the district attorney on appeal to make up these other arguments as to why they were prejudiced, I don't think this court need consider that.
Is it so obvious that there would be prejudice to the prosecution in not granting the continuance, that that's something we should consider?
Well, in terms of the prejudice meaning dismissal?
Right. Now they can't go forward. That seems obvious. Like
Well,
obvious prejudice.
I don't think that's the direct prejudice. However, so first, I don't think that's the direct prejudice, because the prejudice, as we were talking about, as you were talking about with opposing counsel, was the denial of the motion to continue in order to speak with the witness, and whether that could be remedied by the continuance. Now, in another case that led more directly to dismissal, such as Sinet, I would cite Sinet for that proposition, where the prosecutor made a record that we're done here. If you don't grant this continuance, we're done here. That's not what happened here. The prosecution said that we can go forward on the misdemeanors. We're not going to waste the court or a jury's time by proceeding in that way. And so I don't think that we have the same situation that we do in Sinet, which is that the prosecution was prejudiced in a way by not having the victim there, although that's attributable to their behavior as well, and the victims. But they chose not to ask for a bench warrant, and they chose not to proceed on the misdemeanors. They made a choice, and the judge's ruling was responsive to their record that they made.
Well, the victim not being there is not attributable to the prosecution, is it?
Well, I maybe I misspoke, but not having more information at that point was attributable to the prosecution.
Okay.
So I think that under the totality of the circumstances, Judge Hughes was within her discretion to deny the motion to continue. And we would ask this court to affirm the district court's order denying the motion to continue and to dismiss the case. Thank you.
Thank you, counsel. Court thanks both counsel for your arguments, and those arguments will be helpful to the division in reaching a decision. So the matter will stand submitted, and a written opinion will issue in due course. Thank you for being here today, and counsel are excused. And as soon as counsel have cleared counsel table, the other parties or counsel in Para v. Gillespie may come forward and get set up. Good afternoon, counsel.
Good afternoon. Good afternoon.
Is Gillespie, is it Gillespie? Or
Gillespie.
Gillespie,
Yes,
okay.
I know it's not spelled.
Okay, well, I was wondering if we had it misspelled on the documents, but it is with an A, right, Gillespie.
I don't know how long it took me to make sure that my notes were correct when I was writing down my client's name.
Okay, all right. Counsel, do you have any, do either of you, any of you have any questions about our practice and protocol before the court for oral arguments?
No, Your Honor. Your Honor, I don't think so. I understand that Mr. Waters, on behalf of Johnson Excavation and myself, will be splitting the 15 minutes. There is a clock there. I'm going to try to reserve half of the time for Mr. Waters. I don't know whether it's within the court's ability or desire to help me with reminding me to
I-
set up and let Mr. Waters have a turn.
I-
But if the court is so inclined, if you could tell me if I'm beyond 7.5 minutes, I would appreciate it.
I will try to do that, and then it will be up to you to, when you
Mr.
actually
Waters
stop.
can maybe clear his throat or something.
Right. So you want to split it 50-50, basically?
Yes.
Okay. All right.
And do you want me to reserve rebuttal time now, or?
No, you can reserve rebuttal, whatever rebuttal time you want to reserve for responding to both arguments.
And I can do that later.
Yes, you can do that as you wish to do. Okay, with that, the court calls Para versus Gillespie Construction, 2018, CA 800.
Thank you. If it please the court, I'm Ron Wilcox, registration number 13526, appearing today on behalf of the appellants Michael and Michelle Para. As the court is aware, this matter involves a question of when the statute of limitations was triggered under the Colorado Construction Defect Action Reform Act. And under that act, a homeowner has 2 years in which to file a lawsuit from the day that they discover or should have discovered through reasonable diligence the physical manifestations of a defect which ultimately causes the injury. And as the court has stated previously, the statute provides that a claim arises for purposes of its limitation period when the defect becomes manifest. In this case, the issue is whether the discovery of cracks, gaps, sticking doors that are consistent with normal construction and settling of a house constitutes physical manifestations of a construction defect as a matter of law. As the court is aware, this matter was decided on a summary judgment motion, and the appellant respectfully takes the position that there are material issues of fact as to when the Paras discovered or should have discovered through reasonable diligence the physical manifestations of a defect. Here was the progression of cracks, gaps, and sticking doors beyond normal expectations that resulted in the physical manifestations of a defect. In January 2010, the Paras moved into their new house. Everyone agrees that some settling is normal and that some shifting could be expected with new home construction. 2011 through 2013, cracks and gaps started to appear, doors began sticking, and painting and drywall repairs were made. Yet the contractor continued to assure the Paras that the cracks, gaps, and sticking doors that they were experiencing were consistent with settling and were normal. In 2013, the painter, who has come out to do some repair work, tells the Paras that they should call Monty Rhodes of Gillespie Construction, who constructed the new house, to make, and I quote, to make some adjustments. The Paras contacted Mr. Rhodes, who responded and made a list of the issues that the Paras pointed out to him, the gaps, cracks, sticking doors, items of that nature.
Mr. Wilcox, can I just ask a quick clarifying question?
Sure.
So Gillespie does not get involved until 2013?
No, Gillespie was actually involved in coming to the house in 2011 in looking at some of the issues, having some repairs made, and assuring the Paras that the problems they were experiencing were normal.
Okay, and then he says in 2013, you should call this other person.
No, it was the painter guy who had come out to paint over some drywall cracks and things of that nature, who said,
Okay.
you need to get the contractor back out here and make some adjustments on some of these issues, like the sticking doors and items of that nature.
The contractor being Gillespie?
Correct.
Okay.
Yeah. So in November of 2014, the Paras contact the contractor, who responds and makes a list of all the issues that they identify as they walk through the house. In February of on February 15th of 2015, the contractor, through Mr. Rhodes, who's the contractor's employee, indicates that the problems that the Paras have identified exceed those that one would normally expect through the settling of a house. That the gaps, the cracks, the sticking doors are something that have continued to manifest themselves. Repairs haven't been able to address those issues, and so at that point he advises them that they the problems that they're experiencing are greater than ones that they would normally expect to experience through normal settling of a new house construction. So it's Supera's contention that it was at that point that their cause of action accrued.
Okay, then sorry to interrupt, then I have another fact question.
Uh-huh.
So, but there's like a delay, isn't there, between the time when the homeowners have that person come in and say, ooh, you know what, this might not be as benign as we thought, maybe we have a problem here. Isn't there a delay of over a year between the time somebody says you might want to call somebody and the time they actually call someone?
Yes, there is a delay. And I think it was in November, or sometime in 2013, that the paras were advised to have this Mr. Rhodes from Gillespie Construction come out. They waited until November 2014 to contact him. He did come out right away. That's when he made the list of issues. And then it wasn't until February of 2015 that he told them, you know, these are greater than what you would normally expect.
Well, what if they had waited 7 years and then called him and he had said, wow, you know what, I think that stuff you saw in 2011 and 2013 really was not that benign.
Then I think
Too
that.
bad you didn't call me 7 years ago.
Sure. No, I think that in that circumstance, the statute provides for a specific 6-year limitation with some period of repose. That would have addressed that issue.
Okay.
Under those circumstances, they absolutely would have been barred. In this circumstance, when he says, I think you ought to contact Mr. Rhodes of Gillespie Construction and have him make some adjustments, there wasn't any sense of urgency. You know, everything they were experiencing, they had been told were things that they could normally expect. It wasn't as if he was telling them that they needed to contact the contractor right away, that there were health issues involved or structural issues or anything of that nature. Just come out and have him make some adjustments. That
Okay,
was the statement.
So your position is, can you sort of sum up in the principle of what your position is? It's that when the homeowners learn that the damage they're seeing is a result of some sort of a problem, that's when the accrual period begins?
Yes, when it becomes a manifestation of a defect. And I think the Stiff case addresses this right on point. There's a certain period of time in which some normal cracking and gaps are expected to occur, and that's what happened here. And then there comes a point in time when you're unable to correct those defects, you're unable to address them, and they appear greater than what you would normally expect. And I think it's that time that triggers a statute of limitations.
When the physical manifestation is
What-
attributable to something other than like a benign circumstance? Is that a
Correct.
fair way of
Yes.
saying it? I'm trying
When
to think
it-
of a rule that you want us to adopt.
Well, it's, as stated in the Stiff case, it's when the problems exceed those that could normally be expected through normal new house construction and settling.
Okay.
And in this case, we're arguing that that occurred, they were placed on notice, and on February 15th, 2015 is when they were first placed on notice that, hey, we've been trying to address these issues, we've been unable to, so we think that there's something else going on above and beyond normal settling. It wasn't, and we're not arguing that the statute was triggered by when they learned the cause, which are the foundational issues, because they didn't discover that until later, once they got an engineer involved later in 2015. So we're not arguing that the statute was triggered when they found the cause of the injury. That's not the law, and that's not what they're basing their.
But, you know, as the homeowners that begin living in this home in early 2010, I mean, don't they have the most access to see what's happening to their own house? It's not a situation where it's underground pipes or something that they can't see, you know, pipes that are leaking and they don't discover for some period of time. I mean, they can see the cracks and they know these cracks are not something they want as part of their home.
Absolutely. And what they've done, as you'll see in the record, is call the contractor out. The contractor comes out, they make these tile repairs, they paint over some things, they patch up drywall cracks, things of that nature that one would expect in a new house construction with some sort of settling. It's when it goes beyond that stage, when those can't be fixed, that there's a realization that this is more than just normal.
But the Parras continue to have lots of issues, and they would come and fix it, and they would get unfixed again. So at some point, doesn't it become unreasonable for them to, I guess, to take the builder's word for it? Shouldn't they be looking at somebody that's independent of the builder?
And they did that once the builder finally said, these are things that we can no longer fix. They're greater than what we expected or that anyone would expect. And at that point, February 15, 2015, they went out, the cause of action accrued, and they went out and got an engineer later that year who determined that the problem was foundational in nature.
Mr. Wilcox, let me ask you this. How do, even if we could, how do we fit your repeated phrase, more than normally expected, into the language of the statute, which says reasonably, or they knew of, or with reasonable diligence should have discovered the physical manifestations of a defect, which ultimately causes the injury.
Correct.
So it appears the statute just refers to physical manifestations. It doesn't say physical manifestations which are more than normally expected, or substantial, or significant, or any
Right.
other term. How do we get that into that statute?
And I think the Stiff case sort of addresses that. Prior to the time that these problems exceeded normal expectations, they weren't physical manifestations of a defect, they were physical manifestations of what one would normally expect in normal construction. You would see these cracks and so on, and there wouldn't be a way to tie them to a defect. It was only when it became a manifestation of a defect once they exceeded normal expectations. And I think that's addressed through the Stiff case.
Well, how do you distinguish the Stiff case, Court of Appeals case from 2003, from Smith, the Supreme Court case of Smith versus Executive Custom Homes of 2010? It appears from the language in Smith that it may have overruled or reached a different conclusion than you're proposing comes from the Stiff case.
Right. And I think, first of all, in Smith, that was the ICE case, and the discovery
Yes.
was essentially, the date was admitted through the acknowledgement of an email that this accumulation of ice was caused by a construction defect. So I don't think that the discovery issue was at issue in that case. But in United Fire, the court distinguished the holdings in Stiff. There was a language in Stiff that referred to cause of action accruing when the cause is discovered. United Fire acknowledged that that was no longer the law, that that was dictum, that had been overruled. And I agree with that. We're not arguing here that the accrual began when the cause was learned. But more importantly, United Fire did not overturn the portion of Stiff that addressed when a cause of action accrues based on the damages that have occurred. And that, I think, is a pertinent important portion of Stiff that still remains good law.
I think United Fire ruled that the fire itself was a physical manifestation of some defect before there had been any investigation or any knowledge of what that defect might be. So there was not a knowledge of what the defect was at the time of
Correct.
the fire, but that was the physical manifestation. How does that differ from this case?
Yeah, I think in that case, like the other cases, fire was not a normal expected event. And in this case, the gaps, sticking doors, and other problems that were experienced were normal, expected events. And if I could, I'd like to reserve the last 30 seconds here for rebuttal.
Okay, thank you.
May it please the
Yeah,
court,
you
my
may.
name is Stuart Morse, and I have the pleasure and the privilege of representing Gillespie Construction. This case, for all intents and purposes, has already been heard and decided by 2 other courts. This case, I believe, is defined by the Smith case in conjunction with the United Fire case. Those cases fully address the question before this court, and that's whether the trial court properly applied Section 1380-104 1BI in granting motions for summary judgment to both of the defendants. There's no dispute but that there's a 2-year statute of limitations. And that statute of limitations, of course, begins to run when the cause of action accrues. And there's an accrual definition contained within the statute. And that is a claim for relief arises under this section at the time the claimant discovers or in the exercise of reasonable diligence should have discovered the physical manifestations of a defect in the improvement which ultimately causes the injury. That's what the triggering statute says. Plaintiff's appeal requests this court, and I think that's one of the things that Judge Hawthorne, you were struggling with, is they're asking you to rewrite the statute for them and put words in there that the legislature did not, and more to the point, Your Honors, specifically withdrew from the prior iteration of this statute. The language that they're asking you to put in the statute now was once in the statute and was removed in August of 2001. And appellants rely principally on the case of questionable precedential value, the Stiff versus Building Homes case that has also been discussed with Your Honors.
Well, Mr. Morse, I'm sorry, before we get to that, can I ask you a question about Smith, since that seems to be the case everybody says is the silver bullet?
Of course, Your Honor, that's why I'm here, hopefully.
Great. So, as I read the holding in Smith, it seemed to me to say that actually what you have to be able to do is attribute the damage to a defect. So the holding in Smith is, it is plain from the language of the statute that claims under the CDARA, personal injury claims included, begin to accrue when the homeowner first discovers or should have discovered the defect. And then that language is actually interspersed throughout Smith. That the accrual, the thing that triggers the accrual period is the time the defect is first noticed.
Well, with all due respect to Justice Malarkey, I think that was an unfortunate use of language in the statute, because there is elsewhere in the opinion the language that says that it is the manifestation of the defect, and that's really what the entirety of the Smith opinion was. And in that case, the parties agreed, because the homeowner had written an email a year before his wife fell that said, hey, there's ice on my sidewalk, and it's, quote, because of a construction defect.
Right.
And so I think the language in the opinion did not look at much in terms of this question of manifestation versus defect, because it had already decided, everybody agreed there was a defect. Frankly, I don't think that that's in the opinion. There's no real facts in the opinion other than the email from the homeowner to say it was a construction defect. What the nature of that defect is, or was undescribed and undefined, and we don't truly know whether it was a defect or not. I think that the court just assumed that because the parties assumed it. But the court basically said that it's not a case where there's a literal plain interpretation of Section 104. The homeowner can file a claim under SIDARA as soon as the defect is noticed. The homeowner does not have to wait until such a defect causes collateral injury to a property.
Right, but there has to be a
Exactly.
defect that's noticed.
Exactly, and
Right.
that's the point of the statute. The statute says the defect is identified by the manifestation. That's in the statute. The statute says that the triggering event is the manifestation. And in this particular case, those manifestations clearly went back to 2011.
Well, but that's sort of like a post hoc analysis. I mean, I guess what I would say is, when you talk about physical manifestation, that's like a really particular term. And I think of a manifestation, and I think it's in some of the cases when they talk about the dictionary definition, as meaning something that comes from something else. It's based on something else. So if you have a physical manifestation of a defect, it has to be the physical damage that comes from a defect, that is attributable to a defect. And so how I read Smith is that you have to understand that the physical manifestation is tied to a defect, because otherwise, why wouldn't the statute just have said, the first time you notice damage in your house, that's when the period begins to run?
Well, and that's in fact what Smith said, is that that's when the homeowners should file their lawsuit. There's an entire section of the Smith opinion that basically says that homeowners are incentivized to resolve construction defect issues at the time when the defect is first noticed. The notice is the manifestation, and that's what's built into
But they don't say when the
104(1)BI.
damage is first noticed. Then I would be totally with you. If they said the first time you see any damage on your property, that's when you know there's a problem, you better do something about it. But they don't say that. They say the defect. And I'm not so willing to say, well, I think that the Supreme Court just used language willy-nilly.
Well,
I
you're-
think that when they say the thing that triggers the accrual period is noticing the defect and discovering the defect, I think they meant what they said.
If I may, Your Honor, you have to go back to what the legislature wrote in the statute. And the legislature wrote, discovers or in the exercise of reasonable diligence should have discovered the physical manifestations of a defect in the improvement which ultimately causes the injury. So it leaves open the question of whether there's a defect that causes the injury. The question is, the triggering event is, what was manifest? What was the outward appearance? And a manifestation, as the court in United Fire versus Powers said, is something that manifests or constitutes an expression of something else.
Right, of something else.
Right. It's a perception, an outward or visible impression of the problem. And in this particular case, that's the cracking, that's all of these other things that everybody has agreed throughout the course of this case were supposedly caused
You're
by
less than 7 minutes.
a defect. Thank you, Your Honor. And so, but what the thing that I wanted to point to very quickly, because I don't want to take up too much of Mr. Waters' time, is the statute was changed by the legislature to take out the exact language that you yourself, Judge Harris, are struggling with, and that is the original statute removed all of the language that said a claim for relief arises under this section at the time the damaged party discovers or in the exercise of reasonable diligence should have discovered the defect. That's no longer in the statute. In the improvement, which ultimately causes the injury, when such defect is of a substantial or significant nature. And again, that's the language that the paras are trying to have you graft back into the statute that the legislature specifically removed in 2001. And I need to allow my colleagues some time. Thank you for your questions, and thank you for your consideration.
May it please the court. Brian Waters on behalf of Johnson Excavation. I want to pick up on the significance aspect that the Paras Council was talking about. This, it has to be more than something normal out there. And with respect to the significance analysis, it's not in the statute anywhere. We believe that Smith overruled Stith. Smith has looked at significance and determined that something that's insignificant, something that's minor, even in the personal injury context, even though that might be harsh or unfair, it's still a triggering event. And so if Smith has decided that something insignificant triggers, then there is no significance test. There is nothing where you'd have something more than abnormal.
Counsel, is there
More
any
than normal.
is there any significant legal significance to the Paras claiming that they kept getting reassurances from Gillespie and others that this was normal, that this was just normal settling, nothing they needed to worry about,
No,
Is-
not at all.
Why not?
And first off, Johnson Excavation made no representations to anyone. That part of the argument would be frivolous as to Johnson Excavation. But the repair doctrine tells us that you don't rely on your contractor for those things. People are going to have different opinions as to what's going on. Ultimately, if this wasn't a statute of limitations issue, that's for a jury to decide down the road as to what's causing these things. But in this case, with respect to these folks, they didn't believe that these things were ever normal. They were asking for repairs, and this isn't a situation of one wall in one room in one house that had one crack. They're claiming there were cracks all throughout their house. This isn't one piece of board in their house that was separating. They're claiming that the boards are separating and separating over time. Mrs. Parra uses the term hupping, H-U-P-P-I-N-G, that they were curving upward as well, not in one location throughout the house. She didn't say that somebody yanked the kitchen countertop away from the wall. She claimed that in 2011, that the house was shifting such that the kitchen countertop pulled away from the wall. This is a claim about one cabinet door that was sticking. They're claiming that cabinet doors throughout the kitchen, doors throughout the house were sticking, and that this happened over a period of time. This isn't an issue of one thing or any one of those things. It was a progression. The Parras got their drywall fixed in 2011, and it came back in 2012. So there was a progression of things. And this isn't a case where there was no claim of any problem or concern about injury to person. The Parras testified, Mrs. Parra testified, in 2012, she was concerned about the safety of her grandchildren, that they would trip and fall over a problem with the hearth. And that's exactly the way that Smith was decided, that there was a tripping hazard, a concern with safety of individuals, and that was enough to do that. With respect to the cracks in the wall, the problems in the floor, those aren't just manifestations of a defect. We don't have to figure out what the cause is for that to trigger the statute of limitations. Because if that were the case, they'd have to know that, from their perspective, that the house was moving because of something underneath the house, whether it was pylons or piers or a perimeter drain or something else. They'd have to kind of figure that out. The cracks themselves are damaged. There's something going on there. And they believed that. And it's based on what the plaintiffs
Well, that sort
believe.
of sounds like, and I mean, I agree, all of that is good evidence that you could use to try to persuade a finder of fact that in actuality, the homeowners knew there was a problem, that they were able to actually attribute the damage to some sort of a problem. And nobody is saying that the homeowners had to know precisely what the problem was. I think their argument is one level up from there, which is they just had to know there was a problem, that it wasn't benign. So no one's saying they had to know about the shifting soils or anything. That's not their argument. But that sounds like a fact issue. So you're saying, how did you not know this was attributable to a defect? That makes no sense at all. That's a really good argument, but I feel like that's a fact question that could go in front of a fact finder.
Well, Mrs. Parr is the one who testified that she had these concerns, that there was a construction defect, that these are the things that were caused by a construction defect from 2011 forward. In the Smith case, if we look at footnote 3, it talks about, however, as in this case, where the homeowner notices the obvious manifestations of what appears to be a construction defect, it's triggered. You don't have to know that there is a construction defect. It's something that appears, and it certainly appeared to them, and that was the trigger. And again, in terms of the delay was 1.5 years. They say that for sure they knew by February of 2015, and that's the date that the statute was triggered. The only reason that they didn't know until 2015 is because of their own efforts. Mrs. Parra testified that life gets in the way. She was told to go get some advice 1.5 years earlier, and she didn't. Actually, it was more than 1.5 years earlier. She waited 1.5 years, and then it took time for somebody to get out, and then it took time for that somebody to then make some recommendations. So even under the Parra's theory of this case, this backs up long before the statute of limitation.
Yeah, can I just zero down on that for a second? So if you
Yes.
give them the benefit of how long it took the guy to come out there and how long it took him to say, ooh, this is not good, and you subtract that, and so you back up in that way, are they still out of time?
Way out of time. Yes, Your Honor.
Okay.
Thank you, counsel. And Mr. Wilcox, as you said before, you have about 30 seconds.
Thank you.
Rebuttal.
I agree that it was a progression of events that took the cracking, the gaps, the sticking doors from manifestations of normal settling to a manifestation of a construction defect. It was a defendant's burden on their affirmative defense to show that the problems the Parras were experiencing prior to February 15th were manifestations of a construction defect as opposed to normal settling. And the defendants have not done that. They still maintain that all of the problems they experienced are normal.
May I ask a question quickly before you sit down? Is that okay? So Mr. Wilcox pointed out that, and this is set out in the United Fire case, that the statute has changed, and so it doesn't say discovered the defect anymore. Now it says discovered the physical manifestation of a defect. What's your response to that?
That the manifestation of a defect didn't occur until the problems evolved from manifestations of what you normally experience with normal settling, normal construction, to the point where they were greater than those expected from normal settling. And at that point, they became manifestations of something else. And at that point, the cause of action accrued, and they went out and determined what the actual cause was.
Thank you, counsel.
Thank you.
And the court thanks all counsel for your excellent arguments. Those arguments will be helpful to us in reaching a decision. And the matter will now stand submitted, and a written opinion will issue in due course. Thank you again.
Thank you.
The next case on our 2:30 docket this afternoon is People versus Maniscalco. And we have counsel set up at the council table. Any questions from either counsel about our practice and procedure here in the Court of Appeals? Okay. We will proceed then on case number 18CA0003.
May it please the court. My name is Taylor Ivy, registration number 50122, and I represent the appellant, Mr. Maniscalco. The court plainly erred when it resentenced Mr. Maniscalco to an aggravated term of imprisonment without making the required findings on the record. A sentencing court cannot impose a sentence beyond the presumptive range without first stating on the record its finding that a Blakely compliant or Blakely exempt fact is extraordinarily aggravating. Mr. Maniscalco waived his Blakely rights in the event that his sentence to probation was revoked, but it is not clear from the plea agreement, the disposition hearing, or the sentencing hearing whether he admitted relevant facts supporting the aggravated sentence or stipulated to judicial fact-finding.
Do you, sorry, can I, because I saw that in your brief and I had a question about that. Do you mean you can't tell whether he stipulated to judicial fact-finding or alternatively, whether he admitted to the facts, but surely you know he did one or the other?
Yes.
Okay.
I think it's clear that one of the two is what we're dealing with, but I don't think it's clear at all from the plea agreement or from anything that happened at any of the hearings which specific kind of Blakely waiver he was enforcing.
Okay, and so you're gonna say if all he did was waive his right to have the jury find the facts and agree that the court could find the facts, what facts did the court find? Is that the
Exactly.
argument? Okay.
So even if, we can say that by the omission of any specific fact admitted in the plea agreement, he was stipulating to judicial fact-finding, there was not judicial fact-finding as to the specific extraordinary circumstances that would require aggravation at any of the hearings.
What do you want us to do about that colloquy with the judge, where the judge says, now you understand that what you're doing here is admitting that there are aggravating facts and circumstances that would allow me to sentence you in the aggravated range?
Well, I think that isn't specific enough to satisfy the statutes and the case law interpreting the sentencing statutes, because that's not a specific finding of what the aggravating circumstance is. To say just there are aggravating circumstances, it does not put Mr. Maniscalco on notice of what specific aggravating circumstance is making his sentence be outside the presumptive range.
But why would he care? Because he's saying, you're right, there's aggravating circumstances and you can sentence me all the way up to 6 years. I see that right there, written in my agreement. So why would it matter to him, to Mr. Maniscalco, what the aggravating circumstances or facts are? Because he just said, yeah, that's right, they do exist.
Well, I think that due process requires notice of what the specific aggravating circumstances are. And that is from the case that I believe is People versus Lopez. I could be getting my cases wrong, but there is a case and it says that that is not sufficient, that he just had notice in the plea agreement that he was subject to the aggravated range. He needed to have notice about the specific aggravating circumstances that made it appropriate to sentence him outside the presumptive range. Just notice of the fact that his sentence could be aggravated is insufficient to satisfy due process and Sixth Amendment requirements in Blakely.
But didn't your client effectively get the benefit of this bargain? And how can he challenge that when he got exactly what he agreed to?
Because he didn't. He was sentenced to 4 years of probation, which was the stipulation in the plea agreement. That was revoked.
And he violated that?
But at his resentencing, the court didn't properly consider the factors that it should for sentencing in order to sentence him in the aggravated range. Because the presumptive range was 1 to 3 years, and he was sentenced to 4 years of DOC. And just to say, like, I'm going to convert your 4-year probationary sentence to this 4-year DOC sentence is insufficient to satisfy the constitutional requirements for sentencing outside the presumptive range.
You think there's a constitutional right to have the judge say what the aggravating factors are? And
Yes.
I didn't mean that like as a rhetorical question. And where does that come from?
That comes from Blakely, I think. That a sentencing procedure to comply with the Sixth Amendment, the facts supporting the increase of a sentence beyond the statutory maximum, except for the fact of a prior conviction, must be admitted by the defendant or tried to a jury and proved beyond a reasonable doubt unless the defendant specifically stipulates to judicial fact-finding.
Right, but here he waived that Blakely, right? So what's left now is that the judge did not, in your view, did not say with enough specificity what the aggravating facts or circumstances were. But that's not a constitutional problem, is it? That's a statutory problem per Fisk.
It's a constitutional problem because the Sixth Amendment requires that this sentencing procedure be constitutionally fair and satisfy requirements under due process, such as notice of like how and why he's going to be serving more than the presumptive sentence under the statutes. And here that was not satisfied because the court said only that it was going to convert the 4-year sentence. And that's not any kind of factor under Blakely or under the statute. It's just the court saying that I think this should be 4 years because you had 4 years of probation. And it doesn't state what the specific aggravating factor was. And he pleaded guilty to an attempt. And so it's also not sufficient for them to say, well, the underlying crime that you were charged with was heinous, because that's not the charge that he pleaded guilty to. He pleaded guilty to an attempt, a lower charge. And so there was nothing that the court said that would satisfy the procedural requirements to sentence outside the presumptive range here.
The fact that, that the crime involved violence that's not a factor that the court can properly consider?
The court didn't consider that factor. There's nothing in the transcript where the court says this was a violent crime and so I'm going to aggravate your sentence, or, you know, there was violence involved and so I'm going to aggravate your sentence.
Well, I thought the court said it was like, right, it was particularly heinous. He like punched her in the face and gave her a black eye and raped her.
The court said, I remember from your previous hearing that this crime was fairly heinous and now I don't think you've done well on probation, and so I'm going to sentence you to DOC. And I think that DOC term should be 4 years because you had a 4-year probationary sentence. And I think that's also an important distinction, that the court's reason for sentencing to DOC was these other things, the heinousness of the underlying crime that he was charged with, or the fact that he wasn't successful on probation. And the aggravation, the actual sentencing outside the presumptive range, the extra year that was put on, was not what the court said was he didn't say that's because of the heinousness. He said that is just because you had 4 years of probation. And that is not sufficient to aggravate someone's sentence.
Is it your position that there were no aggravating circumstances?
It's my position that he didn't stipulate to any. He didn't admit any in the plea agreement. He didn't admit any at the disposition hearing, and the court didn't judicially find any.
But could the court have on this record? That's my question.
I don't think on this record.
If we were to remand, is it sort of for like a formality, or is your position that there are no aggravating circumstances?
I don't think that this record is sufficient without a remand for the court to find that there were aggravating circumstances, because there must be that specific detailing on the record under the statute in order for that to be sufficient.
But I guess I'm asking, apart from the detailing on the record, set that aside. Do you see what I mean? Because there's sort of two types of problem here. One could be there are no aggravating circumstances. If we sent it back, there's no way the judge would be able to sentence him to 4 years DOC. The other argument, though, which is the one that sort of sounds like what you're making in the brief, is, well, I don't know if there are aggravating circumstances or not, but what I'm saying is the judge did not put them on the record. And I want to know, which of those arguments are you making?
Well, I think it's a little bit of both, because I think this is also a problem with the plea agreement, and Mr. Maniscalco has challenged the plea agreement in a separate case that's on appeal right now. And I think it was a 35C, and now it's an appeal of that 35C having to do with plea counsel and his understanding of what this plea agreement meant, including the Blakely waiver. But here, what my position is just that this needs a remand because there are not sufficient facts on the record to justify the aggravation for Mr. Maniscalco's sentence.
Okay.
Not at any of the hearings, not in the plea agreement. There's nothing in there that is a sufficient fact for aggravation. And this is, I think, a constitutional a constitutional problem. It's review for a plain error. The error is plain because it's clear from the sentencing statutes and Colorado precedent that the court was required to make specific findings on the record. The error affected Mr. Maniscalco's substantial rights because it increased his sentence beyond the presumptive maximum. And there's a reasonable probability this error affected Mr. Maniscalco's sentence. And without the proper findings from the district court, I think this court isn't able to properly review Mr. Maniscalco's sentence. And so this court should vacate the sentence and remand this case to the trial court for proper findings on the record and resentencing. If there are no other questions right now, I will reserve the remainder of my time for rebuttal.
May it please the court, my name is Brock Swanson, attorney registration number 39116, and I represent the people of the state of Colorado on this matter. Under section 18.14091, if a sentence is within a range agreed upon by the parties pursuant to a plea agreement, the defendant shall not have the right of appellate review of the propriety of the sentence. And here the defendant was sentenced within a range that he agreed to as part of a plea agreement. And other divisions of this court have already said that the defendant's claim here, that the trial court did not make sufficient findings to support his aggravated sentence, is a challenge to the propriety of the sentence. So this court should not review the defendant's claim and should dismiss the appeal on that basis. To the extent the defendant is, in his reply brief, trying to construe this as a constitutional claim, I would say that Fisk indicates that when it's considering this claim that it is a statutory claim, and also that I'm unaware of any case that would say that these findings are constitutionally required. So even if we were to review that constitutional claim under the plain error standard, they would fail because they were not plain at the time of trial because there was no case clearly stating that that is the law.
Can I ask a quick question
Sure.
about that colloquy?
Sure.
Where the judge says, now you understand, what you're admitting to here is aggravating facts and circumstances that would allow me to sentence you in the aggravated range. That's not really part of the plea agreement, is it? Is that what he's admitting to under, or is that what he's agreeing to under his plea agreement?
I think that that is not necessarily what was required by the plea agreement,
Okay.
but it is something that he did admit to the court during the plea colloquy.
Does he actually say, I'm sorry, I
No,
didn't
go
mean
ahead.
to interrupt,
That's
but did he actually, when the court says that, does he actually say like, yes, I totally get it, I'm admitting that there are aggravating facts and circumstances?
What was said was, the trial court said, I want you to be aware that's what the waiver, as far as aggravating circumstances, I want you to be aware that that's what the waiver of Blakely means. You are admitting aggravating circumstances apply. Therefore, if you violate your probation, you could be sentenced between 1 and 6 years. Do you understand that? And the defendant said yes. So that's the extent of the colloquy into that.
That's the entirety, though, of his expression of understanding what he just agreed to.
That's right.
Okay, and that is not necessarily required by the plea agreement.
That's right.
Okay.
I would point out, as far as that goes, that I believe is an alternate and also sufficient basis for affirming the sentence. But the first claim that this is not within the range that was agreed upon and therefore is not reviewable is an independent bar to granting any relief, regardless of whether he stipulated to those facts or not, that because this is a propriety claim and because he was sentenced within that range, this is not a reviewable issue. But if this court does review or does consider that issue, the position would be that that statement is sufficient and then therefore under Shepard relieved the trial court of making any additional findings regarding that issue. And then finally, I state that I think the findings here are sufficient. The court made statements regarding the facts of this case before it imposed the sentence that indicated that it found that it was a serious case and deserved the sentence that it imposed. And there's not any particular magic words that the trial court is required to make before imposing an aggravated sentence. I'll just say. So, if there are no further questions on anything, people have asked this court to either dismiss the appeal or affirm the sentence. Thank you.
So it is Lopez that says that the focus of the Sixth Amendment inquiry is on the process of finding the facts and whether it sufficiently complied with the defendant's constitutional jury trial protections. Also, that a defendant's due process rights are not sufficiently protected when he or she is informed the sentence may be aggravated. The defendant must have the opportunity to admit in court proceedings or in the alternative dispute to a jury the actual facts on the basis of which the sentence can be aggravated.
Right, but isn't that what he waived by waiving his Blakely rights? He said, I'm not going to hold the government to its constitutional duty to prove the aggravating facts and circumstances to a jury. What else are you waiving if you waive Blakely?
Well, and I think this was Fisk that talked about how there has to be the subsequent determination of what that aggravating circumstance is.
And that's a statutory problem. That's what Fisk says. Fisk says, we're out of Blakely territory. Now we have a problem in that there was no specific finding on the record, and that's a statutory problem. So I agree that could be a problem, but it's surely not a constitutional problem.
Well, I think it goes to the constitutionality of it because without, I mean, I think that's just the next step in the process. All of this falls under that issue of the Sixth Amendment and due process and what someone requires notice of at sentencing before they're sentenced outside this presumptive range. And I think that's the whole point of the statute is to protect someone's Sixth Amendment rights and Blakely. So without that, I don't think he has sufficient notice. Even if he has said, okay, well, the aggravating circumstances apply, there must be something more after that to tell him what those are. And I think that this is also different because the Attorney General cites People versus Shepard talking about how he stipulated to this 1 to 6 year aggravated sentence. But this is not like in Shepard because in Shepard, the defendant stipulated to a specific term of years. There was, I think, a 16-year sentence and a 9-year sentence specifically that the defendant stipulated to in the plea agreement. And here, the plea agreement, he specifically stipulated to a 4-year probationary term. And then this was kind of just a contingency thing. Like, well, if you're not successful on probation, if probation is revoked, you might be sentenced in the aggravated range, which is 1 to 6 years. There was no specific term of years that was determined in the plea agreement that Mr. Maniscalco stipulated to. So this is not like in Shepard where he stipulated and so completely waived any determination of what the aggravating circumstances might be, I think. So I think that those things, all those things together show that this is a constitutional claim and that Mr. Maniscalco had a right to a sentencing hearing where specific circumstances were found and put on the record for why his sentence was aggravated. And this court should remand for those proper findings on the record. Thank you.
Thank you, counsel. Thank you both for your arguments. Again, those will be helpful to us in reaching a decision. The matter will stand submitted, and a written opinion will issue in due course. That concludes our 2:30 docket for today, and therefore the court will stand in recess and the bailiff may so announce.